Hi everybody, I'm Chris Morgan from techgc.co.uk. The purpose of this video is to give a very quick overview of a contract review and how you do that. So before we look at how you do a contract review itself, we just need to quickly ask, what is a contract? Might seem like a silly question, but actually a contract could be anything from a conversation on the phone, an exchange of emails, because under English law, a contract can be oral or in writing or a mixture of the two. And fundamentally, a contract is a legally binding set of promises. So what does that mean? So one party says, I'll do this if you do that. And it could be performing a service in exchange for money. It could be providing goods in exchange for money. It could be a combination of those things, or it could be some kind of technical collaboration, and so on and so forth. So key risks include entering into business activities, a business engagement with somebody else, another entity. But there's insufficient structure, so it's not exactly clear where the contract is. There might be numerous bits of documentation, if any. It might not be clear who's doing what or what the costs are going to be. So just generally sort of vagueness if things aren't pinned down sufficiently. And that can lead to you not getting what you wanted out of the relationship. Can lead to costs overrunning if there's no clear way in which costs are controlled or set out in the contract. And it can lead to liabilities over compliance issues if there's a data protection issue that's not sufficiently dealt with in a contract, for example, or intellectual property issues. So if another party to a contract creates risk for you by using third-party intellectual property without consent, by taking and copying things and providing it to you, then this is all creating risk. So to understand what the risks are in a particular circumstance, it's always a good idea to do a contract review before signing it. So what does that mean? Well, we'll look at that on the next slide. So whether a contract is a contract with a supplier, a customer, a technical collaborator, an agent or a distributor, these are all sort of high-level issues that it's important to consider. So firstly, the context is incredibly important. So before doing a contract review, it's always important to consider, what are the circumstances? Are there any particular risks from a business point of view if this doesn't work out or if this goes wrong? Are there particular timing constraints? Are there particular issues that relate to the specific activities that are going to be happening that are important to make sure are covered off in the contract for complete clarity? So it's good to do that before even looking at a contract. If there's a draft contract that's been prepared, just take a step back and consider the bigger picture. And then, so what's the overall structure of the contract, and does that match with your expectations? Does it match with what will work to optimize the business relationship? So is it a one-off contract, or is it a framework that will sit in place over a number of months or years even? And does it roughly kind of match your expectations in terms of length and complexity, and does that match with the complexity of the circumstances? These are useful things that it's important to ask up front. And then diving into other key terms and so on. So date, duration and termination, obviously that's an important issue for any contract. What's the date of the contract? So when's it going to be made? And there's a distinction between when a contract is made and when it's effective. When does it take effect? Sometimes those are the same thing. Two parties can sign a contract and then that kicks off a project. Or if activities have in fact already started, or if they're going to start in the future, then what's called an effective date can be specified in the contract. It's important that there's a distinction between that effective date concept and the date on which a contract is entered into or a contract is made, because a contract is always made when it is entered into, when it's signed by both parties, and it's the effective date that you can use to specify starting in the past or in the future, and so on and so forth. The date on which a contract is made is when it's signed and entered into. That's important because if you put a date in a contract for the date the contract is made, but it's in the past, then that amounts to fraud, actually. So that's not a good thing. Anyway, that was a slight diversion on how to specify the right date. Also, it's important to think about the duration and the termination. So is the duration a fixed period, or is it fixed for a project, or is it ongoing? Is there automatic renewal, or what is the sort of scope of termination rights that you have? How can you get out of it and when? And then the fees and costs, obviously important for both parties to have clarity on that. So what's going to be charged and when? How's it going to be invoiced? And how can payments be made? What are the payment terms? Then think about quality of services, quality of goods, quality of performing obligations. So are the standards set out in the contract? Is it important that services or goods meet certain requirements? And if so, are those set out? Are they set out in warranties, which are kind of contractual promises that services and goods will meet certain requirements? Or is there an element of risk in terms of the contract not being very specific on quality requirements? And then if the quality requirements aren't met, what are the remedies? So is there a right to return goods or a right to receive a refund, and so on and so forth? What are the remedies if services don't do what you're hoping them to do? And then linked with that, what's the liability position? So how much risk and financial responsibility are the parties taking? Are the parties standing behind what they're going to be doing sufficiently? And do they have insurance in place? And what insurances do they have in place to provide the other party with some comfort if things do go wrong? And then intellectual property. In a tech context, this is always important. It's always important to think about what IP terms a contract should include, unless you're just buying pens or something. But even there, if you're buying pens that have your logo on it, for example, so you've had to provide that to a supplier, then you want to check the scope of rights that the supplier has in relation to your logo and make sure they can't take it and change it and run with it and do other things with it. You just want them to make the pens. Confidentiality is also really important. Maybe you've already entered into an NDA with a third party, or maybe the contract terms in relation to confidentiality are going to supersede or replace an NDA essentially. So it's important to think, what information are we providing, what are we receiving, what controls do we need to put in place over that information to make sure that it's going to be protected, particularly if there's going to be sensitive confidential information, whether that's technical information relating to technology or products, or information relating to your business or your finances. What do you expect the other party to do, to have in place in terms of controls around how they use that information? And change control. So this is relating to what happens if a party wants to change what's happening under a contract. So change the scope of services, order some additional goods, and so on and so forth. May or may not be relevant in particular circumstances, but in some scenarios it's a very good idea to have an explicit change control procedure to give some certainty around what happens if there needs to be a change. And then compliance. So this could be anything from data protection, if that's relevant, if there's an exchange of personal data, if there are export control related issues, if there's a supply of technology cross-border, then export control considerations kick in. There might be health and safety or environmental regulation compliance issues depending on the scope of what's going on. So having some terms that deal with compliance in a proportionate way can be really key and also very important. And boilerplate, now this is the stuff that lawyers get particularly excited about. It's the stuff that everybody else probably dozes off when they're trying to read. But it's the stuff towards the end of a contract, and actually it can be quite important and have implications on some of the areas that we've already spoken about. So for example, if a supply contract has a force majeure clause in it, then it means that the supplier is able to not take on any liability if problems arise that are beyond its reasonable control. And what that means comes down to the words on the page, how it's defined in the contract. So if reviewing a contract for a customer, then I would be looking to make sure that the force majeure provisions aren't too broad, so that the supplier can sort of wheedle out of responsibility in different circumstances where really they should be in control and they should be responsible. Boilerplate would also include things like the right to subcontract or assign a contract, transfer it to somebody else, provisions in relation to waiving breaches, provisions relating to severing different parts of the contract if they're found to be not enforceable. And also governing law and jurisdiction can be quite a key one. Think about what governing law and jurisdiction actually makes sense. What would you like to have in a contract with a third party, depending on where the parties are? And dispute resolution is something that it's useful to think about, depending on the circumstances. You might have a short form dispute resolution clause, you might have something a bit longer, depending on how significant the relationship is, how much money is being spent, and so on and so forth. And then finally, think about whether there's anything unusual in the contract. And this is where a lawyer, someone with some experience, can help in terms of pointing out things that are a bit unusual or beyond standard market practice, anything that creates anything particularly onerous, or anything that you think, well, that's a bit odd, why is that there? If you're thinking that, that's probably a very valid question, so something that should be thought about in a bit more detail. When you've gone through all those key areas, bearing in mind, of course, what the context is, that can inform how much detail you need to go into on all these areas. You can also then arrive at a risk assessment overall for the contract based on all of those things. Are there red flags, meaning that actually the contract as a whole is a red flag contract? Now, that would be something that has significant risk in my mind, significant risk for the business, significant legal risk, and therefore it needs very senior review with the CXO, review with the CEO, possibly the board, to make sure that it's something that the company understands what the risks are and wants to proceed anyway because there's a business imperative of some kind. Or the risks can be mitigated, of course, and that risk mitigation is a really important part of the conversation. Something that's amber rated is probably something that is generally okay. There's a few areas that aren't ideal, perhaps. There might be a few medium risks, but this is also a good candidate to discuss what appropriate risk mitigation would be. So where there are certain risks under the contract, what can be done practically to make sure that risks are mitigated as far as possible. So adverse financial consequences, adverse legal consequences don't arise. And green, it's, there's very few contracts that are ever perfect, but perhaps low value, low risk contracts on reasonably standard terms would be rated green, and then that gives you a bit of a framework to think about, well, how good or how bad is this contract? Does it need some work before we sign it? Would it be best to update some key areas, or does it need a complete rewrite? That's all a conversation that can be had after the risk review is completed. So there we are. That was a very quick overview of what a contract is and what a contract review should include, so that it's a useful tool to help you understand the risks before signing on the dotted line with a contract that's been proposed. And contract reviews are things I can undertake on a fixed fee basis. I can talk with you to understand the context, understand the risks, understand the right level of approach that's proportionate with a particular contract. For instance, I could do a bronze review, which I think of as being a red flag review, just sort of highlighting some of the key risk areas. I could do a silver level contract review, which is looking for those key risks and also providing a summary of all the key terms of a contract together with the risks and risk mitigation suggestions. And then a gold level standard of contract review would also include a contract markup, so updating the contract to make it more balanced or make it more favourable to you and protecting some of your key risks and key interests. And the contract markup itself could be light touch, it could be more of a middle path, just updating the key areas, or it could be very detailed if there are significant risks and a significant relationship that's going to be encapsulated in a contract. And that is what contracts should do. They capture the parties' intentions, they align expectations, and provide a pathway for a business relationship to unfold in a way that protects both sides and is also beneficial to both sides. So I can work with you to understand what level of contract review and markup you might like in particular circumstances based on the risks. And then I'm more than happy to help on that basis. So do get in touch with me if you've got any questions or you'd like to discuss how we can work together. So I'm Chris at techgc.co.uk. Thanks very much for listening.